Good morning, and thank you for coming to this morning's program, Practicing Immigration Law Under the New Rules. I'm Paul Trister, Program Planning Lawyer for the Law Society. It gives me great pleasure to welcome our all-volunteer faculty today. They've given very generously of their time and talents and in reacting very quickly to fast-changing developments in this area and preparing the materials you have and the presentations that you'll hear today. You'll be meeting them in due course. I just have a few quick mundane announcements. I'm obliged to remind everyone that this is a non-smoking facility. Those smokes can be grabbed just outside the east entrance where you came in. Inside that entrance, you will have noticed a staircase. If you follow it to the bottom of the stairs, there are pay telephones. A rather severe jog to the left around from there brings you to the men's washroom. The women's is most conveniently found by walking through the main Law Society reception area and down the stairs. Most of you are registered as well, I believe, for the afternoon workshop, Huddle with the Experts. For those of you who are not, I understand that there's still a handful of places available in those workshops, and you may wish to inquire about that at the registration desk. The materials you have consist of a binder and I believe 7 handouts. I just want to draw your attention to the course evaluation form, which is in the binder proper and is a crucial document for us. This is in large measure what guides us in planning programming that will best meet your practice needs, and you would be doing us a great favor as well as acting in your own self-interest to keep it by you during the course of the day's proceedings, to complete it and to turn it in at the registration desk at the morning's end or the day's end, as the case may be. If for any reason you omit to do that, please do mail or fax it in. We read each one, we take them seriously, and I believe it's fair to say we profit from them. I'll introduce, you'll notice that all the faculty are set forth in the biographies at the beginning of the binder, so I won't dwell on that except to very briefly introduce this morning's chairs. Already well known to all of you, I'm sure, Marshal Drukarsh, certified by Law Society as a specialist in immigration law, author of the immigration law column for the Criminal Lawyers Association newsletter, and Howard Greenberg, likewise certified by the Law Society of Upper Canada as a specialist in immigration law and a member of LSUC's certification committee responsible for certifying lawyers in immigration. Please join me in welcoming our chairs. Thank you.
Thank you very much, Paul. On Saturday, let me do it appropriately. Colleagues, government partners, ladies and gentlemen. On Saturday, November the 18th, the Canada Gazette contained proposed immigration regulation amendments. As you will learn today, the government proposes to streamline processing, reduce their resources, centralize independent selection procedures, while at the same time increasing the discretionary parts of assessment, language and adaptability, from about 29% up to 36% of the decision. They are intending about 85 to 95,000 independent workers. Without an educated bar to help them, the system will surely implode. I looked at the proposed amendments last Saturday, and this Saturday, November 25th, I bought my kids a decent computer. I think I'll need it, and I think that we may be in a situation where I'll be able to afford it. Because the perfected applications have created a situation where everyone will need a lawyer. I congratulate you all on being here today to learn about the new system, to learn about those changes. In particular, I want to thank our faculty who have so generously come to us from New York, Buffalo, Ottawa, Mississauga, North York, and Toronto for both this morning's program and the afternoon seminar sessions, Huddle with the Experts. The faculty that we have gathered here today, whom you will see, include Mr. George Sy, Assistant Deputy Minister of Partnerships, Ms. Elizabeth Ruddick, Director, Economic and Demographic Research and Analysis Branch, Ms. Doreen Steidle, Director General, Selection Services Line Branch, Paul Delaney, Director, Case Research and Review Directorate, Charles Godfrey, Director of Reconfiguration and Operational Support, International Services Group, Ms. Denise Defoy, Deputy Director, International Services and Program Coordination, Mr. William J. Van Stulden, previously a director and director general of various immigration groups and areas, now the manager of a number of initiatives having to do with selection. Mr. Murray Oppertshauser, program manager, immigration, Buffalo. Mr. Del McKay, head of immigration, Canadian Consulate, New York. Ms. Natalie Smolnik, LLB, desk officer in litigation management, citizenship and immigration, previously a visa officer in New York, New Delhi, and Old Kiev. Mr. Frank Pericoli, manager, special services, Mississauga case processing. Ms. Wilma Jenkins, program manager, inland directorate, Ontario region. Mr. Brett Bush, program specialist, enforcement and control, Ontario region. Ms. Chantel Ramsey, manager, business immigration section, Ministry of Economic Development, Trade and Tourism, Ontario. Also, permit me a moment to thank our lawyers who've joined us. Publicly, on behalf of Howard and I want to thank Ms. Jacqueline Bart, David Bruner, Gary Siegel, Robin Seligman, Peter Rakai, Joe Young, Canadian Bar Association Ontario Chairperson Ben Trister, Mr. Lauren Waldman, and the grandfather of the immigration bar, Cecil Rotenberg, all of whom have participated in the planning and the organization of this and who are going to be joining us sometime through the day. I look forward to this being one of the most important programs that I've ever attended, and it's because of the hard work of all those people. I thank you and look forward to your participation. Howard, if you'd like to introduce the material in your portion of the program.
Could everyone take out their binders a moment? When I used to do these programs in the old days, we used to get really bad evaluations with respect to the materials because the materials were so comprehensive that nobody could follow them during the session, and then after the session they couldn't figure out why they were in the binder. So we've decided to do things just a little bit differently. We're going to tell you a little bit about the materials for about 1 or 2 minutes so you understand why we put them in the binder and how you can use them in your practice once this session is over. There's a table of contents which I prepared, which is immediately before the first tab number 1. Decided to do tables of contents a little bit differently from now on. In addition to telling you what the document is, we're going to try to describe the document to you and give you a little bit of insight as to the future of the document, if it's going into an OM, or how the document came about. We find that procedure to be a little bit more effective a week from now when you can't remember the conference and you're left with the binder. In tab to quickly run through the binder, and tab number 1 is something which lawyers don't normally get their hands on, which is a renewal bulletin. It's the announcement by the then Deputy Minister, who's since been renewed himself, as to the new configuration in Ottawa. And that's very important for us as lawyers. A lot of the times we have to know who to call and what kind of presentation we want to make. And so I included this renewal bulletin to let you know who the new players are in the game, to let you know that Mike Malloy in Ontario is really important. He's one of only 3 now running across the country, and to let you know that everybody should learn how to spell Shepit, because he's the new Director General Case Management, and when something's going wrong on those files and Murray Oppertshauser won't take your telephone call because he's not in, Bill Shepit is there for you, and he's there because this new organizational chart makes him there for you. So you really want to take a fast look at it and know who the players are. The following tabs relate to each one of the programs in the same order. So you will see at tab 2, there's a press release on skilled workers, which is the departmental announcement on the changes which Marshall just spoke about. In addition to that, I've included in a separate tab the regulatory impact statement. I, as a lawyer, always go to the regulatory impact statement to understand why they did what they did. And usually when regulations change, I quote from these regulatory statements when I make presentations on behalf of my client that a certain effect was to be achieved by a change. See the regulatory statement to confirm it. So I suggest that all of you read the statement carefully. It's probably the best analysis outside of what the government has just started producing in the roadshow, which Liz is now doing, on what's going on. The regulation is there. The regulation comes into effect on February 8. I guess with all regulations, you're just going to have to read it with your existing regulations side by side. It's not consolidated. You're going to have to take out the does and the ands and delete an and whatever. You've got some material here which I don't think has been widely circulated yet. In tabs 6 and 7 are the guidelines for the new language criteria. That's tab 6. And in tab 7, this new factor that's worth 12 points called adaptability, which is everything in what we're doing from now on. And there's a very nice detailed discussion of the adaptability factor, so you should take a really quick look at that, because that'll form part of our discussion with Elizabeth and this afternoon in your question period for those coming to the seminars. The next tab it goes into Cecil Rotenberg's presentation. There's a telex that's now gone worldwide explaining certain service standards. We are the government's partners now. We're entitled to get certain types of treatment on our files. And that treatment is outlined for you in a telex, which is in tab 7. Now, why I think you should read it really carefully is it's in effect as of November 1. So, surprise. There's a great letter from Cecil. Cecil only writes great letters. And that's in the tab 8 on some preliminary issues with respect to this new processing procedures which are coming into place in Buffalo on December 1 and other offices as we go along. I'd read the issues very carefully. There are some serious issues for lawyers here related to negligence and duty to clients, and Cecil's comments are very well taken. Clients may be in very serious problems depending on the timing of the filing of their applications. I have included, we've gone out and got these one-step processing kits from various visa offices that have implemented the program. I've included the kit in the materials for Hong Kong, for Buffalo, and for London, England, which is also running this new procedure. I would say to you that Murray from the Oppertshauser, the program manager from Buffalo, tells me that the version I have in here that I acquired about 2 weeks ago is a little out of date. And he has provided in the materials another version of it, which is in a envelope which was handed out as part of the binder materials. So you read Murray's, throw mine away. There'll be another one, I think, Murray on December the 1st, etc. So this is an evolution. You know, they're learning at this game. So you got to understand the packages will keep changing as they find problems. Cecil's going to speak a little bit about medical inadmissibility, and some of it's pretty sophisticated. If you can't follow it, I wouldn't worry about it. His submission to the government's in tab 12. You can read it at your leisure and figure out how to use the cases that have just been decided in the last 2 months to benefit your clients. Tab 13 is the OM and the delegation instrument for rehabilitation. That's also the last panel with Paul Delaney. And you may want to take a fast look at the OM if some of you haven't seen it to understand what kind of criminal cases Murray Oppertshauser in Buffalo can decide all by himself without sending them to Ottawa. And lastly, I just threw in an OM on student authorizations with respect to some regulatory changes that kind of occurred in the dead of the night, which affect student authorizations for dependent children. Something you should just be aware of. The rules have become a little looser on it, and you should be using it. So, otherwise, I think it's a really good binder for your office. If you have any questions that arise from the program, myself and Marshall are opening ourselves up for discussion afterwards. If you write me or you email me or you in some fashion contact me, the dialogue is not over today. It's only beginning for a system that's going to change so radically that they're cutting $54 million by March 31st, and we're basically going to be doing everything for our clients but signing the visas. So our role has changed significantly, and today is actually a perfect opportunity to understand what we can do to help our clients. Thank you. I guess I'll take that next step since we're the first panel. There's been a core group in Ottawa that have been working on these changes. These changes have, I don't know when the first thought started on changing it, Elizabeth. You might do better at that. But there's been a constant feeling in Ottawa that we're selecting the wrong people. If you'd read the Globe and Mail for the last 2 years, the famous Mayor Burstein would be saying things like we should be selecting the cream of the crop, and we're getting the wrong people, and the data shows us that the people that we're selecting are the people that aren't performing the best. To that end, we've seen some patchwork regulatory changes over time, changes in EAR points, for example. No need for sponsorships anymore for brothers and sisters. This is all moving towards putting points behind the applicant and assessing the applicant based on his or her particular merit. And this regulatory package, in my view, is probably one of the most significant changes in the newest direction in the way in which selection is going to turn. We're going to be very careful in presenting this to you. We're going to go really slow, and if it seems elementary for some of you, please bear with us. These regulations are very complicated. To understand why you've done it, why they did it, will greatly assist you in understanding how to apply these regulations and what kind of strategies we can use to get the best out of these regulations for our clients. So in a non-invasive way, I'm going to turn the podium over to, you don't believe that, do you, Elizabeth? I'm going to turn the podium over to Elizabeth, and Elizabeth's going to take her time for about 15, 20 minutes to a half an hour with some overheads and explain to you very clearly what they have done. And then we're going to embark on a little bit of a discussion. Now that I hear what Elizabeth's done, I'm already thinking how I'm going to twist the system as best I can as a lawyer to get results for my client. And then we're going to have a little bit of a question and answer period to allow you a chance to vent a little bit and either tell Elizabeth what you think or ask her a couple questions. So Elizabeth, I'm sorry, I should probably be going back to my organizational chart for you, huh? The Director of Strategic Planning be appropriate?
No, still Director of Economic and Demographic Research.
Okay. Elizabeth is a numbers person. She's got a master's degree in economics. She's a person that's been there through the evolution of the process, and she's probably one of the best suited people to talk about how we came to this point and how these regulations should be interpreted. So please.
Thanks, Howard. I think I'm going to give my presentation from here, and then I'll put some overheads up as I go along just to help you in seeing what we've done. What I'm going to do is speak for about 15 or 20 minutes and give you a very simplified view of why we made the changes, what prompted the direction that we moved in, what supported the changes that we were proposing, and what those changes look like in terms of the new selection criteria. So it isn't a guide to each specific regulation and subparagraph. It's a very much broader perspective on where we're going, but at the end of it you should have some idea as to what the new selection criteria are, how important they are, and what the package looks like as a whole. As you are probably all aware, these changes were announced in November of 1994 as part of the Minister's strategic framework. And in respect to the economic component of the program, the framework has two prongs. One is upgrading and updating the selection criteria for skilled workers. And I should say right at the outset that I'm not going to discuss business immigration in this presentation, and that these changes don't affect the current business program. So with respect to skilled workers, the Minister announced that he'd upgrade, update, renew the selection criteria, and then that he would also look to increasing the share of that component in the overall immigration level. We've consulted very widely. We've been working on this for at least 3 years, if not longer, and over that time we've consulted with a very wide range of experts and interested people, provinces, lawyers, academics, business. And there's been a general consensus that the way that the criteria are structured now, with the very detailed list of occupations, with the points for occupation that no one, and occasionally even Citizenship and Immigration, can quite figure out, with a program that's fairly reactive and that's very narrowly focused, the consensus has been that it needed to change, that it needed to be updated, and that we needed to move away from very narrow focus on an individual's occupation and look more at things that were really important over the medium and long run, like education and language and adaptability to the labor market. At the outset, what I always like to say is that to remind people what the program is designed to do. The program is designed to enhance the Canadian economy through selecting workers who are able, because of their skills, to make a positive and lasting contribution. So it's very much an economic program and economic focus. And that's what distinguishes it from the other immigration classes, in particular family and refugees. What we're looking for is immigrants who can hit the ground running, who can start to contribute when they come to Canada, who can find jobs, and who can get right into the labor market and be productive almost from day one. To give you some idea of the size of the program, and this is a program that is for skilled workers destined to provinces other than the province of Quebec. As you know, Quebec has its own selection authority and it runs its own program for skilled workers. Its program is very similar to ours. The kind of people who are selected under the Quebec program are very similar to the people that we are and that we will be selecting. So outside of Quebec, right now, we're looking at 25,000 skilled workers and assisted relatives who are selected as principal applicants. And they bring them with them, and this is a rough order of magnitude, about 35,000 dependents. So the total is about 60,000 and rising. That's excluding Quebec.
Is that 1995?
No, that's a sort of a rough 94 number. I mean, these are ballpark numbers. These are not down to the last person. This represents about 1/4 of all immigrants who enter the labor market. So of all the immigrants who enter the labor market, 1/4 are selected as principal applicants, skilled workers or assisted relatives outside of Quebec. Howard mentioned that we want to change the program because we're not selecting the people that we should be selecting. Our data and our research tells us that on the whole, the program is working fairly well, that the people we've selected in the past have very high employment earnings relative to the people we don't select in the order of twice or higher. They earn more than the average Canadian, and that's an indication that from an economic standpoint, there are benefits from the program. But what we've noticed over the past few years is that we're admitting people who don't have language skills, who have difficulty when they come in. We're admitting people who have, or we were certainly until the changes we made to 1993, admitting people who had less than secondary education. And you all know that if somebody is entering the labor market today and they haven't finished high school, the probability of them doing well is very low. The probability of them finding work that pays reasonably is just as low. So what we're looking for is to select people who have the same kinds of skills as we would expect from our children or from new Canadian entrants to the labor market, or from people who are in their 20s and mid-20s, mid-30s coming on to the labor market or changing jobs. The current system focuses too much on precise occupational niches. It looks at an individual's occupation and it awards a lot of points based on that occupation, the skill level of the occupation, a variety of factors that I'll come to later. And it isn't really well suited to an economy where it's the experience and the education that you bring with you related to the occupation that is as important or more important than the narrow occupation that you practice. And the system right now, the way it's designed, is biased in two ways. The first is that it allows for selection of applicants who lack language skills, and particularly high-skilled positions, professional occupations, where people typically have a university degree. It is fairly easy for them to come in with very poor language skills. The number of points that they accumulate for having this kind of occupation, the level of education that's consistent with it, mean that they can get by with very low points on language. And the converse to that is that highly skilled trades and technical workers who may well have a good command of English or French have a great deal of difficulty getting into the system. And in fact, our sense is that they don't even come to the door because they know that they're not going to pass. I'd like to spend a couple of minutes running through some of the research and analytical findings that have led us to the selection criteria that we're proposing here. as I mentioned, right now, on the whole, the program seems to be working well in that skilled workers earn more than other immigrants and more than the average Canadian. So what that tells us is that, by and large, the kinds of selection criteria that we're using are the ones that we should be using, and that the outcome of the program is what we want. The analysis that we've done also shows that language and education are the most significant predictors of economic success. So if you look at the points that are awarded for language and education to someone when they arrive in Canada, and you look at their earnings over time, language and education are good indicators of their potential earnings, and personal suitability is in as a, shall we say, a close third. It's also an important predictor. So the value added from the visa officers is important in the success of the program. What are employers looking for today? We keep saying that the labor force is changing, the labor market is changing, the economy is changing, and employers are looking for different skills in their potential employees. The Conference Board 2 or 3 years ago did a survey called Employability Skills Profile, and they asked employers what they were looking for, and the kinds of things that they found were communication skills, numeracy, ability to learn, positive attitudes to personal growth and development, and adaptability. And those were the most important factors required of the workforce. The last thing that I want to comment on from the research side is language. And if you have gone through the regulations, the proposed regulations and criteria, you'll notice that language is more important under the proposed criteria than it is under the current system. We find that immigrants who have a knowledge of English or French on arrival earn significantly more than those who have no knowledge of an official language. That's not surprising in and of itself, but what is surprising is that this differential persists over time. So if someone arrives without a knowledge of English or French, it takes a very long time, and you could argue, if ever, that their earnings rise to match those of people who come with a knowledge of the language. So there seems to be a big advantage in arriving with a knowledge of English or French. And bear in mind again that this is an economic program, and that the success of the program is judged by the economic performance and the contribution of individuals to the labor market. And the other point is that language capital, and this obviously follows from what I just said, language capital is one of the most important human capital investments for an immigrant to make. And if an immigrant comes to Canada and doesn't have English or French, they certainly can find work in an environment where their mother tongue is the language of the workplace and where they can use their mother tongue. But they tend to be very limited in terms of their access to training, their access to other employment opportunities, job mobility, and their earnings power if they stay in that environment. We just completed a study that looked at the use of ethnic networks in finding jobs. And what we found is that immigrants who used their ethnic network to find work tended to be ones who had poor language ability, and they found jobs, but they found low-paying jobs, whereas immigrants who had a knowledge of English or French tended to move out of their ethnic network and find higher-paying jobs. And this is true even when you compared people with the same levels of education or the same occupational experience. So I can't overestimate that importance. So what are we doing about this? Well, one of the things that we are having to do is to change the occupational classification system that we use from the CCDO, that you all love so much, to the NOC, which is a system that's been in use by Human Resources Development for a number of years now, and which is a much more updated set of occupational definitions and classifications, and is a much more aggregate set of definitions. So you will no longer find our favorite occupations of crossword puzzle maker, humorist, or the one that I noticed on the list was handbag designer, which I thought was sort of interesting. Not to say that we don't need handbag designers, but so we're switching to the NOC. And switching to the NOC has a lot of pluses for us. It has a minor drawback, which is that our specific vocational preparation factor disappears, but you'll see that that's probably good too. But the NOC is organized in a very interesting way that makes a lot of intuitive sense. It's organized by the skill level of the occupation, and it's organized by the segment in the labor market that that occupation fits into. And so what we've been able to do is, now, just show. Yeah, that's better. What we've been able to do is to select from the NOC those occupations which are skilled, and so we've excluded low-skilled occupations. Anything that needs less than a secondary education we deem as being not a skilled occupation. And we have taken the occupations that remain and we've divided them into 4 occupational categories. The reasoning for this will come clear later on, but what you need to understand just now is the 4 groupings and how they distinguish themselves. The 4 categories are professional, where you have occupations like computer engineers, financial analysts; technical, industrial designers, instrument technicians and mechanics; trades, tool and die makers, machinists; and skilled administrative and business. And you can see right away that each one of those addresses a different segment of the labor market. And if you can see the overhead, you'll also see that the typical employment requirements or entry requirements for these occupations in terms of the level of education differs. So if you're an engineer, and lawyers are also in the professional category, you'll be pleased to know you need at least a university degree. If you're in the technical group, community college; trades, you need high school or apprenticeship program; and skilled administrative and business, a university, first level university degree. So you can see that each of the 4 categories is distinguished by a minimum level of education. It's not a bar to entry in the occupation, but it certainly is the typical requirement for that occupation. The occupations that we have included in these 4 categories are specified in regulation, and the regulations also specify them by the 4 categories. The regulations also indicate that certain occupations will require arranged employment. Right now, we require, for example, doctors, nurses, lawyers, teachers to have arranged employment if they're going to be assessed as a skilled worker. And that will continue to be the case. And that list of occupations requiring arranged employment will be published on an administrative basis about once a year. And I can come back to these details. I will come back to these details later.
I was only going to mention that in tab 3, excuse me, you will see the occupations listed under the 4 headings, and an asterisk indicated for each of those occupations is the one for which arranged employment is. Give you an understanding as to context Elizabeth's comments are made in.
But I should say right now, don't get excited at this point in my presentation about the number of asterisks that you see on the list. We'll come back and I'll explain why we don't really have more occupations requiring arranged employment now, in the proposed system than we do now. If you think back to the research results and what I was discussing about the Conference Board employability skills profile, you will already have a hint that what we're trying to do is focus on transferable skills, language and education, adaptability to the Canadian labour market. Language and education will be more important in the selection criteria, and skilled workers in all types of occupations will be treated more equitably, and so we won't have we'll be removing the bias that says if you're a professional in a highly skilled occupation, you can come in without language, but if you're a skilled trades or technical worker and you have a knowledge of English or French, you're out. So we're going to be correcting those biases, and we're also going to be introducing tools to manage the level and composition of the movement. The minister announced that he would be limiting the number of skilled workers, and towards the end of my presentation, I'll explain how we're going to go about that. In terms of the new criteria, the regulations certainly appear complicated. It's a large package. What we've done is introduce regulations for a whole new system of selection. We've also got in the regulations changes to reflect the fact that we will be running two parallel systems. One, which is the current system, which will remain in place for business immigrants, and then the proposed system, which will take effect on February the 8th for the skilled worker category. So it's a complicated package. But what I'd like you to think about is not those complications, but to focus more on the criteria and the way that the system is designed, because I think that in the end you'll see it's a fairly elegant system. And it isn't a system that's inordinately complicated. In fact, the smaller elements of it you would treat the same way as you do now. There's some changes. The most important things are changes to the weighting and changes to the pass marks. But I think you'll find that the criteria that are assessed now are assessed generally in the same way under the new system. We've got rid of some of the major irritants and complicating factors of the current system, like these points for occupation. We've got rid of an occupation list that's supposed to change every quarter, but nobody can quite figure out the rationale for the changes. So I think you'll find that the system is generally simpler, easier to understand, but there are some differences that mean that the outcomes will be different and some of the applications will change. All applicants will be subject to the same selection criteria regardless of their occupational category. So it doesn't matter if you have an engineer or a tool and die maker or a financial analyst or a bookkeeper. They are assessed against the same selection grid. But there will be different pass marks for each of the four categories, and I'll come to that in a minute. The new criteria focus on transferable labor market skills. And I'll run through what each criterion is, the weight, and how it's changed from what we have now. I should say at the outset that there are no points for occupation in the new system. I can say that again, but I think everybody's heard that. Knowledge of official languages, knowledge of English or French, is worth 20% of the total in the new system. And there will be new guidelines, and you have a copy of the proposed guidelines in there in a fair amount of detail. That's probably not exactly what's going to go into the manual, but you'll have an idea as to what we're looking for from that. One of the important changes is that first and second languages will be weighted differently. Right now, as it happens, we award 15 points for language, which is the same as we're proposing under the new system. And of the 15, 9 is for your first official language and 6 is for your second. And so what happens, and it's not in all countries, but in some countries, you can be pretty mediocre in English and French and accumulate a fair number of points. You're not good enough to work in either language, but we still give you points for language. And the objective is to award people points for language reflecting the fact that they can work in that language. So we're changing the weighting to 12 points for the first language and 3 for the second. So it's great to be bilingual, but we really want somebody who can function in at least one of the languages. Education and trade certification is worth 20% of the points. And the major difference here is the recognition of apprenticeship and trade certification as a level of education. The rest of the criteria in education are very similar to the criteria that are in place now. The other difference is that we don't look at where the program leads. So we had programs that led to university or not to university or all over the place. We've been able to eliminate that, and we've been able to simplify the regulations for the different levels of education. I'm going to skip around on the list now. Recent experience is worth 9% of the total marks. The most significant change here is that we're looking for at least 1 year experience in the last 5. Right now, it can be 1 year of experience anytime in your working career. But we want the experience to be recent. We don't want people going around and sort of what we've called occupation shopping. We want people to have experience that they've acquired recently, where there is at least some sense in an objective way that this experience will be relevant to the labor market. What you did 10 years ago, at least how you did it, is quite different from what you're doing in your work today. And that's true for all occupations. I don't think it's hard to think of occupations in the groups that we're looking at that haven't been touched by technology and computer and communications changes, and that continue to be affected by those changes on a daily basis. So we're looking for recent experience, and that is effectively a bar to processing, as is the case now. So you need 1 year of experience in an occupation that is in the schedule and the regulations. Age is worth 12% of the total, and the change here is that whereas right now the range is from 21 to 44 for the maximum points, what we're looking for is a maximum points in the 25 to 35 year range, decreasing on either side as it does now, but decreasing more gradually at the higher end. So if you're over 35, you'll get somewhat fewer points than the 9 the older you are, but the decrease is fairly gradual, whereas it's more significant at the lower end. We're looking for people who will be in the Canadian labour market for a fair number of years. We're looking for people who are flexible, who are willing to take a few risks, willing to move around a little bit when they come in, and aren't so set in their expectations that they'll wait for a long time for the perfect job to come along. Adaptability is a significantly revised personal suitability factor, if you will. Personal suitability right now is resourcefulness, initiative, and motivation. We've expanded that, and we've provided guidelines to look for a much broader range of factors that are not assessed by the other criteria. So they're not assessed by age or education or language. But some of the things are, has the person, how prepared is the applicant to move to Canada? Do they have a good idea as to what it's going to take to find a job? Do they know what their occupation is like? Have they done some homework and some preparation? Have they studied in English or French? Have they worked with a multinational? And in your handout, you've got our guidelines for that, and I can come back to that again in some more detail. And that's worth 16% of the total points. Arranged employment is worth 4%, and that's for a validated job offer. It's not an informal job offer or a letter of offer of employment. And the bonus, and we don't call it assisted relative anymore because there's no assistance. We're just saying, do you have a close relative in Canada? The points for that at 5% have the same weight as they do under the existing system. I would like to come back to the labor market balance factor as I talk about the tools for managing the movement of skilled workers, because then it will make some more sense to you. I'm going to spend about 5 more minutes on this and then open it up to questions. Actually, sorry, just a little out of whack here. One more piece that you need that My slides didn't. There it is. Okay. One more thing before I go to the limits. We have 4 occupational categories. We have 1 set of selection criteria. And what we've done is we've developed separate pass marks for each of the 4 categories to reflect the fact that the education level required by a professional is different than the education level required by skilled trades. If the skilled trades has more education than is required by the occupation, that's great. They'll get more points. And the same thing, obviously, for the professional. If the professional has a PhD and they only need a first-level university degree, they get more points. But the education level differs. And I don't think you should get too anxious about writing down all these numbers, because you're not going to have to fit your applicant to this rigid mold. In terms of language ability, if you're a professional, you need to be fluent, you need a better command of French or of English in the workplace in Canada than if you're skilled trades or a technical worker. What you read is more technical. You have to write reports. You have to deal with your team or with your workers. If you're in technical or skilled trades, you have to read the technical documents. You have to know how to operate the machines. You might have to read blueprints, do that sort of thing. But the requirement on you to write, to communicate complex, abstract ideas is not as great as if you're in a professional or skilled administrative profession. Those are the 2 differences, and apart from that, what we're looking for is 2 years of experience. 4 years is sort of what we'd like in the skilled trades. Somebody who's between, say, 24 to 39, we're not forcing them to be 25 to 35. And on adaptability, we would like to see somebody who got, say, 8 out of 12 or some reasonable number of points. We did a fairly extensive simulation looking at 5,000, sort of 7,000 down to 5,000 cases to see if these pass marks would give us the kinds of successful applicants that we were looking for. And we found that by and large, the people who passed using this sample, who pass under the proposed system, have the characteristics that are here or fall within them. They're not absolutes, but it's the profile of the people that we will be looking for. So once your applicant has been assessed against each of the criteria, then the occupation that they're in determines the pass mark, and from there you can determine whether they succeed or not. Now, I haven't talked about this labor market balance factor, and I haven't talked about how to manage the system, and I'll just spend a few minutes doing that. The minister will set annual limits on the 4 broad occupational categories. And what we're trying to do is achieve a labor market balance, not across each individual occupation, and that's what those funny points for occupation are supposed to do now, but they don't do it at all. But we're trying to make sure that we have a system that's not dominated by engineers, or that's not dominated by tool and die makers, and so that there's a broad balance across those 4 categories. The labor market balance is the first of a series of tools that we have to manage the flows and to manage the limits in those categories. Limits are not applied to Quebec. Obviously, Quebec system is separate, and limits are not applied to people who have arranged employment. They are outside of the limits. The arranged employment is a program that's in response to employers' needs, and so we don't see any reason to limit it. As we go through the year, there will be very continual and careful monitoring of the number of applications, of the number of visas issued. As we go through the year, the labor market balance factor can be adjusted to manage the flow of immigrants in a particular category if that flow appears to be significantly different from the annual limit. So if we start to see a very, very large number of applications come in one of the categories, we can lower the labor market balance factor. And conversely, if we're not getting what we want, we can raise it, but not above 10. 10 is the maximum, and 10 is where we will start the system. So that's a front-end management tool that we plan to use. And then if we find that that is not effective, we have provisions, and we will be amending our fees regulations. We have provisions to return applications with the fee if we find we are not in a position to assess them or to issue a visa because the limits have been reached. I don't, we've staged, we have several tools and we've staged them because we don't want to find ourselves in a position of returning visas, or sorry, returning applications with the fee. But if we are to manage to a limit, then we do need provisions that will allow us to manage effectively to the limit, and so we need those provisions in there. But the front-end tool will be the labor market balance factor. We've done an impact analysis on the distribution of successful applicants by source country, and what it tells us is that the top 10 source countries for successful applicants under the current system are the top 10 under the proposed system. This is based on our simulation results. And the ranking changes very insignificantly. And the top 10 in both cases still account for 70% of the total of successful applicants. And once you get below those top 10, you're looking at countries that account for sort of just over 1% of the total, so you're looking at fairly small numbers. So that suggests to us that despite the increased emphasis on language, that applicants from countries where English or French is not the mother tongue are learning English or French and are successful in meeting the criteria. So that's quite encouraging for us. That's all I'd like to say in terms of the presentation. Howard, I'll turn it over to you to manage questions.
No, actually, Elizabeth, before we do that,
Which one do you want, this one?
I want to tell you about another selection system, the one that I see.
Do you want this one too?
Yeah, that's it. Look, I don't want to be crass about this, but our objective as lawyers is to win. To be successful in cases, to allow ourselves to control the process as much as possible, to permit immigration to control the process as little as possible. If you really think about it, if they controlled the whole process, you don't need us. You just fill out forms. Elizabeth makes some interesting observations about what the data has shown in terms of the types of people who have been approved as against the checklist. Well, and I say thank you. I've done a great deal to mold my clients so they looked a certain way, so they were the statistics that Elizabeth's talking about, and that's exactly my point. I have never seen a system that is so susceptible to marketing your client like detergent as this one is, and there's a lot of work for lawyers to do, an awful lot of work, and that work has to be done immediately in the application. This is a unique day in that there's two processes that are happening all at once. No sooner is Elizabeth telling you about this, that you're going to have Murray and the gang telling you on how they're doing things differently in Buffalo, New York, and everywhere else in the world, and that they're doing everything in one-step processing, take it all in at once. So your packages, your documentation has to look a certain way to make it through this meat grinder, and at the same time make it through the expedited processing procedures that Murray wants to do to get rid of your file as quickly as possible. So our role has changed considerably. It's not the long haul anymore. And so I'd like to make some observations about this same criteria that you looked at from the point of view of a legal practitioner who's trying to win. Firstly, the definition of arranged employment. Arranged employment has taken on a new meaning. we have, under the current system, we have never had in our firm a lot of recourse to arranged employment because with 470 occupations, we just threw the dart and picked another one. Elizabeth has taken away our occupations and replaced them with a different process, which may very well put you in a situation where you are in a closed occupation situation, and you're going to have recourse to arranged employment. The role of a human resource center, I believe that's what they're called now, is fundamental to what we're doing for a number of reasons, and which I'll explain to you. But I want you to pay attention to a subtle change which occurred in the regulatory terminology, which I'm absolutely delighted with. I wish it was more of a visa officer power, but I guess I'm told it still is, and I shouldn't worry. In the schedule to the regulation, which is in tab 4, actually, we're going to read some regulations together, I think, if you don't mind, just to kind of help with the clarity. Arranged employment in paragraph 1(1)(b) fundamentally changes the role of the National Employment Officer from simply looking at the adverse impact on opportunities for Canadian citizens or permanent residents in B, which is the normal test, the Canadians First policy. But look what they slipped in. Unless the employment of the immigrants in the national interest. For some of us who've been doing this a little bit of time, you may remember that the Canada First policy was in play a couple of years ago, and that officers used to turn their mind into whether or not the corporation receiving this immigrant was going to really derive a benefit from receiving him or her. And if so, there could be a national interest to bringing this person in, which would override all the advertising requirements. Well, there it is. I don't think, I'm not going to advertise anything that I believe is in the national interest. I'm going to tell Micheline Bouchamont, say hello, Micheline, up there from Canada Employment Center, exactly what the national interest is in as many cases as I can. Why would I do that? I get 3 points on the occupation, I get 3 points in the assessment process, but quite apart from that, there's an interesting little thing that's happening here. We used to live with occupation lists that opened and closed. And we were in my office, they literally, when they closed, how many did we have in the pipeline? How many were on their way to the visa office that are now going to fail? Now we have a situation in which the minister can close down a skill category based upon it not meeting the plan. And the mechanism is not clear for that yet. We're a little ways down the road to seeing that implemented. But those persons who are not vulnerable to that change are people with arranged employment. So there's a really neat way, not only of getting a couple of points, but also of staying in the game when the game changes. So I would place a lot of emphasis on that in terms of strategy. That's my first point. My second point is adaptability. Adaptability is discussed at great length in the regulatory impact statement, and I recommend that you all read that statement. Because adaptability in and of itself is a meaningless term. You have to understand the context with which Murray Oppertshauser's officers in Buffalo are going to apply this adaptability criterion. If I could just, for one moment, turn to the regulatory impact statement, because its language is kind of interesting. At page 2 at the bottom, something that's now going to become part of my discussion with clients. I'm sorry, we're in tab 3. I'm sorry. I'm trying to get my teeth into this adaptability thing so I can figure out if my client's adaptable. Then how do I express it in writing to an officer who's trying to make a decision without an interview? That's the name of this game. It goes on to say the qualities assessed in the personal suitability criteria have proven to be good predictors of economic success, and that's the current 10 points. However, job search skills, flexibility, resilience, Positive attitudes to growth, development, learning, and change are also important. Adaptability will replace the previous appraisal of personal suitability, expanding the assessment to include these additional qualities. And I'm not going to take an issue with the fact that those qualities may or may not be relevant to one's. I'm not an economist, so I'll accept it at face value. I will, however, take a closer look after spending more and more time with Cecil Rotenberg. I actually start reading regulations more and more. I understand why Cecil has so much fun. The regulation for adaptability, which is at page 17 of tab 4, says units of assessment shall be awarded on the basis. I'm sorry, it's page 17 of tab 4, which is the actual regulation. On the basis of the applicant's experience and qualities other than those assessed under 1 to 4, 6, and 7, to reflect adaptability to the labor market in Canada. So number one, we know from case law anyway, there's no double counting allowed. You can only take certain factors and select on them once. You can't keep using them over and over again against an applicant or in an applicant's favor. But quite apart from that, this is the regulation. And what Elizabeth and her group have put in their background materials and the regulatory statement and additional materials on OM to come are their impression of the guidelines to guide the visa officer. But I should tell you, they're not my guidelines, and they better not be your guidelines. It is whatever you believe a person's experience and qualities are as you can explain or present on paper. That's what the federal court judge will be looking at on your application. Those words are the determinative words. We know OMs are simply guidelines. This is so important in an area where there's 12 points out of a possible 52 for a concept which is extremely subjective in nature. And consequently, you really want to put your best foot forward on behalf of your client. And I don't think, and what I'm telling you is not something that goes against what Elizabeth is doing. If there are other attributes that affect your client's employment, which are relevant to his or her adaptability, by all means express them. That's the whole exercise here, is to try to figure out somebody. This whole thing is all about whether or not we're selecting people who, when they get fired from their first job, can get a second job within a reasonable period of time. That's what it's all about. How much bounce does an applicant have? And so it's your job to put that bounce in the covering letter and figure out everything you can to assist in doing that. If you don't think you have a significant role to play in that regard, I'll refer you to the guidelines which they have put out in tab 6. And you are supposed to refer to I'm looking at the middle of the page, which is the 4 major groupings under which the scoring will occur. The ability to adapt to the Canadian work environment, effective job search and other relevant labor market skills. I've actually started cutting stuff out of the Globe and Mail now and sending it to my clients. Preparedness to move to Canada, and positive personal qualities such as flexibility, motivation, initiative, and resourcefulness. Now, I don't know what you think that means, but that means the door's wide open for me to talk about anything that's good about my client that would have an impact on them being able to survive here after they get here. That's what that means to me. And if you look at some of the discussions in the guidelines, for example, if you turn the page, where they flesh out that criteria in a little bit more detail, you can see that unlike probably every other selection system in the world that attempts to create parameters for your consideration of somebody's prospects, can you imagine criteria that are so wide open so as to look at working in Canada, worked or studied abroad and demonstrated an ability to adapt, frequently visited Canada, competent with the current work environment technology? I mean, remember those Lotus certificates that we never included before? Effective job search skills, preparedness to move to Canada, who you've contacted and why. Number 4 is one of my favorites. Positive personal qualities. Positive attitudes and behaviors such as honesty, integrity, and personal ethics. Those aren't ours they're talking about, it's our clients. That was for you, Elizabeth. But you can see, we're going to become public relations officers, and I don't know where this is going, except that there are 12 points which take this real seriously. And this is 12 points on paper. The last thing we want to do is have our client fly in from Hong Kong to determine his ethics in Buffalo. So that's another important, so as I read these regulations, I'm thinking about that. What else am I thinking about? I'm thinking about a really interesting little change that occurred. Let's go back to those regulations a moment, because it's funny how you add a word and you take away a word, and all of a sudden you've changed the whole body of case law. And I'm back to page 15, recent experience in Schedule 1.1. Which is in, tab 4. It's the regulation, page 15 of the regulation in Schedule 1.1. And if you look down to number 3, recent experience, yes. Okay, I will. Actually, you may want to say a few words. You've got time. You've got lots of time. If you want to say anything.
Well, I'd say continue and then...
Yeah, whatever. Jump in anytime you want. Look what they've inserted. Let's go down to B, or the equivalent. These people are not cold-hearted. You can, now I think when I see those words, I start thinking to myself, I got 4 months in summer, I got 3 months in the fall, I got 2 months. I'm starting to make myself a quilt to get that 1-year threshold satisfied so that Murray can give me my visa with no interview. And so that's what you should be thinking. Equivalency lays all sorts of interesting issues open. For example, the University of Waterloo co-op program. You know, PhDs that do a lot of that work on contracts while they're actually studying and getting that PhD. Interesting point. They're out there working at Northern Telecom, doing a contract. Well, that's people. The old days, the visa officers used to say to us, "That's part of their education." I used to say, "Wait a minute, that's equivalent to work experience. They're out there actually doing the same job they're going to do once they get the PhD." And Northern Telecom takes them personally, takes them on full time. So why do we not want to give credit for that? Well, that's your job to wring out the resume and squeeze out as much as you can in work experience to get points in that area to make it over the threshold so your client doesn't fail. The next point is the use of discretion, which hasn't been talked about. But look, no system can select people. You have to understand the impossible exercise of selecting 60,000 people with an 8-point system that attempts to really evaluate all walks of life around the world. And no system can really do it perfectly. And all you hope to do is get people who end up as productive members of society. But at the end of the day, we as clients are going to see people that don't fit. They just don't fit. And at the end of the day, you got to say to yourself, what do you do with somebody who doesn't fit? And what you do is you tell Murray, you don't mind if I do this, do you? Keep using your name, do you? In New Delhi, they hardly ever refer to you. And Section 11 lives. The old Section 11.3 is now Section 11.1, and it lives. They've played with the terminology a little bit, but not in a substantive way to change what it is they were trying to do. I'm going to go to the regulation, but I'm not going to read this one to you. It's a lawyer's dream. I'll just tell you what it means. Okay, Marshall. It's on page 7 of the tab 4. And all I'm going to say to you about this is that they have there is a mind to Cecil's case in the Supreme Court of Canada, The idea about the old 11.3, our justices have determined our economic based discretion, not personal values in this particular section. And you're really looking at reasons why an individual cannot be, the points don't reflect that person's ability to become successfully established in Canada. But that person may very well, on the merits of their particular background, work history, inventions, whatever it is, what qualities they have about them, can pass. If you don't do that in the cover letter, you don't have another chance. You got one bite at this apple, and you better take advantage of that bite. And so Section 11 is there, and it's there to overcome a number of things. It can overcome the 1 year of work experience, 9(1)(b), 1(i). It can overcome the inability to score 52 points. It can overcome a requirement for arranged employment, the asterisk on the other list. This is a very compassionate section for the profession. This gives you an opportunity to be in the game when the system says you're out of the game. And so you use it. It's not described as an exception to the rule in any strong sense, in the sense that you can only use it in a few cases. It's to be used in the appropriate case. If you overuse it, they won't believe you anymore. That's the bottom line. But if you've got somebody who fits, use it. I'm going to speak about one more thing. This annual limits. This is a very disturbing concept. The idea that doors open and close in Ottawa and visa offices around the world is a very disturbing concept. People employ our services for a number of reasons. First of all, our expert knowledge, and that we guide them through a process that's otherwise murky. That we give them some predictability, that when they pay up their money, that they understand what's going to happen to them, and that we are going to be there to hold their hand and help them through this process. And when you disable me from doing any part of that function, as a lawyer, I get really nervous. And if doors are going to close on my client, I want to see that door closing so I can slip on the inside of that door, or I can tell my client not to waste their money. This exercise is not a valuable one for them to go through at this time. The regulation, while you still got your regulations open, on page 9, I don't know how the wording of this is. Maybe the wording will continue the way it is. Maybe it'll be changed. I don't know. There's been some discussion.
It has to do with the Act. It has to do with the Act. The wording in the Act.
Oh, right. 114, you mean, in the powers. Mm-hmm. Right. Mm-hmm. I understand. So it's not going to change, because it's tracking the same wording in 114.
Right. Yes.
Okay. So a visa officer is authorized not to assess visa applications in respect of each of the prescribed classes referred to where the minister considers it necessary for the purposes of complying with the immigration plan. Well, that was probably one of the most notable sections that I saw when I first read these regulations. This visa officer can stop assessing my application at any time. I guess you'd have to receive it first before you could stop assessing it. You don't think so? You think I'm wrong on that? You'd receive it, put it into play, and then hold it in abeyance.
You have to have it. I mean,
This is not the section that turns them away. You can't file.
yes.
It is a section.
Well, there are several. Well, Denise, you speak to this.
Okay, I'm sorry. I just want to understand it.
That section is I'm sorry, Denise Defoy from the International Service. That section is to allow for when we know we have enough application in the pipeline to allow for the maximum number of visa we may deliver. That will allow the visa officer to refuse front end. That is, we'll take the application, and if the applicant insists, and we'll take the application and say, we're sorry, we cannot assess because of the numbers, and then we'll issue a refusal letter based on the limits. When a refusal is done purely for numerical limitation reasons, the processing fee will be refunded. So it would be just a go-around, basically. But it will not be, we won't be creating backlogs. This is what allows us not to create backlogs.
Okay, so I don't want to get too deep here. So, but at the same time, I'd just like to go down this road just a touch. So I file with Murray in Buffalo, right? and Murray takes my application, and they're supposed to be assessing these applications really quickly under this new procedure we're going to hear about shortly. Almost instantly, a couple of days. More or less. I'm not talking about a visa, I'm just talking about some assessment being made,
you're
right?
talking about the perfected application.
Right.
Yes.
So I don't have any rights vested at any time in that process. Obviously, when I paid my money, I have no rights vested when I filed my application. I guess my rights vest when somebody does a selection decision in a computer and says I'm in.
Well, what we're planning to do is to very closely monitor. We're almost on real time in terms of monitoring from headquarters how many applications are coming in and in what band and all that, so that if we can go up to here and we see that we're going like this, then there's a number of measures we can take. If it's early in the year, we can change the labor market balance factor. If it's later on in the year, then we can use this provision.
So this is really after you finish tinkering with those parts of the system you can tinker with, like the labor market factors from 0 to 10, you can start dropping those points and having people fail on their assessments. This is your last recourse if your flow is still too high.
Correct.
And do you contemplate a notice out to the public that in about 30 days we don't see we're going to? We don't know yet.
We don't know yet.
Okay.
Some of us were toying with the idea of having a 1-800 quota line or something like that, that would, so people would have an idea how much the class is filling up. But we're not there yet.
So Marshall, would you like to? That's it. That's enough.
Okay, you heard Howard ask a couple of questions. Now we'd like you to have an opportunity, and it's our intention to do about 15 minutes or so of questions. Then we're going to get into a coffee break, and then we're going to do our next panel. Everything should be moving along through the coffee break and the next panel 5 or 7 minutes faster than in your program, because there's so much to be covered in the third panel in terms of one-stop processing that we need that extra time. Questioning, Joseph?
Denise, just to continue on that line, if the application was sent back, is that considered a refusal?
Yes.
So on the IMM8, have you ever been refused a visa before you have to tick off yes?
Yes. But it's not because a person has been refused before that it's, normally when a person ticks yes on the IMM8, then we ask for more.
That doesn't make sense.
When a person ticks yes, then we ask for more information. And then if the person says, yes, I was refused because the limit was reached, no harm done.
So for those who are going to buy the tape, the question was, is a refusal on this cutoff considered a refusal? The answer is yes, but the explanation hopefully will show it wasn't personal. Giddy?
I think, first of all, it's important to note that on our retainer letters, I think we should start making notes to our clients to the effect that, we could be preparing this application for you, we could submit it. Yes, we are of the view that you meet the criteria, but if it gets back because they filled the quota for the year, you should make some provision, I think, with your clients about the question of fees, and the question if the thing could be kicked back. My question, though, is with respect to the occupations in the NOC. I mean, the thing has been sitting on my shelf, I don't know for how long, I've never even looked at it. Are all the occupations in the NOC in the schedule?
No.
So how is that going to be different than the way we have the demand list right now? You're on the list, you're not on the list.
The way that the list works now is that every single occupation that's defined in the CCDO is eligible either without arranged employment if it's on the list or with arranged employment if it's not on the list. What we've done now is we've said if the occupation is low skilled, and if you're familiar with the NOC, it's basically levels C and D, and there are a few other occupations that we've excluded. You are not included as a skilled worker, and you are not eligible even with arranged employment.
And that can't be overcome by 11.1?
No. If the occupation is not on Schedule 12, that cannot be overcome by discretion.
Okay, I have a question in the second row, then a question from Howard, and then a question in the fourth row over there, sir.
Thanks. Warren Kreitz from Ottawa. The regulatory impact analysis statement talks about these new criteria as being perhaps more objective or more transparent, perhaps than the last ones, or the current regime is. And on its face, I don't see that. I see a lot of subjectivity, a lot of discretion. I think Howard touched on that. I'd just like you to expand, if you could, perhaps, on what's said in the regulatory impact analysis statement to help us understand in what ways, what material ways, these are any more objective or transparent than the current system. That's my first question. Second question is, the same statement says that the federal government is going to work very closely with the provincial government on developing an aggressive promotional agenda to recruit more highly skilled workers. And I just wonder if you could tell us what you mean by that.
The criteria that we're proposing are more objective in several ways. The first is that we don't have points for the occupation, which are difficult to understand, difficult to interpret, and in effect don't manage anything, don't manage what they're supposed to manage. We have criteria that are not geared to the individual's occupation and everything that goes with that. So they're not geared to the fact that somebody is a professional and therefore needs a high level of education and therefore gets more points. So they remove the biases. And they also include, I think, better guidelines on language and better guidelines on adaptability. Right now, there are no guidelines on personal suitability. There's just one sentence. But much better guidelines that will give you an indication as to what is being looked for in those criteria. So it's in that respect, and putting more emphasis on education with again, a better definition.
Thank you.
Elizabeth, I just wanted to ask you a brief question. These things are coming into play on the 8th of February. So on the 9th of February, this is what I see is going to happen in terms of the evaluation of the 1 year of work experience. The problem with the NOCs, in my view, is that when you read the page that describes an occupation, it describes what the entrance requirements are and suggests entrance requirements which are maybe relevant from a local point of view, but in terms of transplanting someone from another country, the NOCs may, for example, indicate that for example, a librarian should hold a master's degree in library sciences, which I represent librarians around the world who've worked 10 years in a library but don't hold the master's degree. What I'm concerned about is that Murray is going to fail my client because he's reading that NOC page and he's importing selection criteria which may not have been intended. So all I want you to do is comment on that.
So is the question whether selection criteria in the NOC are to be read literally?
Right, yes.
Thank
you. You could make the same argument right now for the CCDO, and what we're looking for is have people actually perform the duties of the occupation. So
just to be absolutely clear, an officer should look not to the requirement in the NOC, but the NOC is a guideline. That officer should look beyond that to what that applicant has actually done to determine if they have the experience in an occupation.
Yes.
So it's not rigid. Thank you. There was a question, fourth row.
Yeah, my name is Defoy. I have a concern arising from your comments regarding the use of country statistics. You said that you had projected these criteria and looked at what impact it would have on different countries. Now, as you know, as lawyers, we're concerned the charter prohibits you from looking at nationality as a criteria for the selection of immigrants. A few years back, when your team designed that criteria that brought in the Russian engineer who couldn't speak English, there was a concern that you were following a political agenda, i.e., let's throw the doors open to Eastern Europe. Is there something happening right now with these criteria that is perhaps that we've got too many Chinese?
No, there's nothing happening, but if I didn't do the analysis, you'd probably be the first person to ask me the question of the impact on individual countries. And so what we do when we do these, and I mean, we need to do this, we need to understand what the impact is. We need it for a lot of reasons. Is we do it and we look at it, and the answer now is that there is no impact. But you know, as an analyst and as a policymaker, I have a responsibility to look at what the impact is going to be and to see where the changes are going to affect, and to make sure that in the end we do the simulation to see that the people who pass have the characteristics that we want. But there's no hidden agenda there.
So that was a response for the microphone's purpose to a question concerning the impact on country standards and whether there's some balancing in terms of countries there. Before we go further, I think the last thing we're going to have time for is a response from Denise Defoy to a question that was asked earlier that you've been saving your response because I didn't give you an opportunity.
Okay, I'd just like to say a few words about the promotion and recruitment. As you probably know, the department has been involved in very active promotion and recruitment activities with provinces, with some professional associations around the world. There have been some general promotion campaigns, which is basically raising the awareness that Canada is a good place to come and immigrate to, and some more specific campaigns of recruitment, more for, let's say, engineers in India or something like that. So this is ongoing and this is continuing.
I'd like to thank you very, very much for your assistance and participation, and to you, Ms. Ruddick, and to Howard. I look forward to all of you being back here in about 15 minutes so that we can start the next panel. Thank you very much.